This video is an extract from an interview where an art professional shares their top tips for artists. Thanks for watching, and we hope you enjoy this video. Hi everyone, welcome to this webinar with Jon Sharples. He is an intellectual property and commercial art lawyer. He is one of the best known advocates for artist rights in the UK. So he advises clients across creative industries, particularly the art market and museums. He's the go-to lawyer for artists and galleries. And he's also, if that wasn't enough, because that's plenty, an avid collector and curator. Regarding copyright and intellectual property, as an artist, when you've created a work in the studio, do you automatically have copyright to that artwork? Or are there anything you need to file or apply for to say, this is mine, I have the copyright?
So in most countries in the world, artists or anyone creating original works, so I said artists, but actually even any person on the phone doodling away or writing text immediately becomes the owner of the copyright in the text or the drawing that they've done. There's no registration requirement. And the one serious anomaly in that picture in the world is the US, where they have a copyright registration system. There is no such thing as a copyright registration system in the UK or anywhere in Europe. When people use the language of intellectual property, even in quite sophisticated places, that language is used very casually, inaccurately. And so sometimes people interchangeably use the terms copyright, trademarks, patents as if they're all the same thing. And they are different categories of rights that do different things. So if you're doing something that means you would actually genuinely like a trademark for what you're doing, that is a registration process. And there are formal processes and filing fees associated with getting trademarks. But in the main, artists are interested in copyright. That's something you become the owner of automatically.
So if I made a sculpture or a painting in my studio and somebody was using images of it online, for instance, without my agreement, or worse, putting it on t-shirts, what do I do then? Do I need to prove, hey, I made it? Because I have the copyright, right?
Yeah. So there's definitely a practical hurdle that whenever you're taking enforcement action, either in a legal setting or even in a setting that isn't legal. So if you are approaching a social media platform and using their copyright reporting tools, partly what those tools will say to you is, well, how can you demonstrate to us that you are the copyright owner? And one of the deficiencies of online enforcement tools are actually, as a creator, it may be that all your work's online and that you can point to your own website and say, look, here's the thing on my website or here's the thing on my social media account. But actually, it may be quite difficult if your work, for whatever reason, and there are lots of good reasons, doesn't exist online in a legitimate place. It's quite hard for you to prove to Instagram that you are the copyright owner in the thing that you say you are, or that you might be writing to a host of a website. There's all kinds of tools for getting things taken down. And there are not necessarily legal processes, they're just the tools set up by the online platforms. In terms of using legal processes, I'm a big advocate for artists using the small claims procedure in court, which sounds like a real kind of complicated thing to do. We have a system that says if what you're claiming is a financial amount of less than £10,000, then you can make a claim and you don't need a lawyer. The system is designed to help you and recognizes that you might not have the legal language to describe what's happened, but you just can describe factually what's happened. And also, crucially, for those small claims, if you lose, you don't have to pay the other side's costs. Because one of the things that is a serious feature of most kinds of litigation is that the unsuccessful party pays the other party's costs. And that can put people off a legal avenue, even when they know they're in the right. Because if you go up against a better resourced opponent, you really don't want to have to pay their legal bill if somehow they manage to win their legal claim against you. So I'm a big fan of using small claims. And sometimes if the enforcement mechanisms online aren't working, then a small claim is a really good way to get it up the chain and get the attention of the people who need to take it down. So a good example of that is during the pandemic, TikTok. The use of TikTok exploded by about 20 times, the resources it had for policing IP infringements only increased by 50%. And so there was this huge mismatch between the new demands being put on their enforcement system. So I had a client whose videos were just being straight up ripped off Instagram and uploaded onto TikTok, in some cases getting millions of views. And none of the online reporting tools that TikTok had were having any effect. And so I said to him, listen, we're going to have to file a small claim. We wish we didn't, but we have to. And the day we filed the small claim in the morning, by the afternoon, TikTok had disabled the infringing account just because it had gone straight up the chain in terms of who was paying attention.
There's lots of different bits that you mentioned there. And I think overall, it's about not being intimidated by these things. Also, having this trail online and saying, wait a minute, I made this post a year ago, is actually a way to have this digital trail that this is your own intellectual property.
Yes, that's very true. And if I had £1 for every time someone had said to me, there's an old wives' tale in relation to, let's say, a film script or a play script. And every now and then someone says to me, should I print a copy and post it to myself, record the delivery so that I have a timestamp so that I can prove to a court that this existed at a certain date because I'd have a timestamp? It's a totally insane suggestion. I have never heard of a single case where I just imagine this incredible theatrical scene where someone produces a sealed envelope that hasn't been unsealed to prove the date that a script existed. It's a silly idea, but with a sensible underpinning, which is it's quite good to have a way of demonstrating the date at which something came into existence in the absence of a registration system. So although I've slagged off the US approach and said their system is anomalous and silly and that you need to register copyright, it's also true that having evidence of when something was created can sometimes be difficult. So email is a great tool for timestamped evidence. And so one example that it's a bit counterintuitive is if you're someone who's going to pitch to a corporate, maybe a TV studio or a fashion label or something, and you've gone in and you've had an in-person meeting and you've showed them your designs or your ideas. Some people think, well, it would be crazy to actually send them a digital document because then they could just use it and rip it off. But my point of view is, well, actually, the best evidence you have of the date at which they had access to the thing that you've shown them is that if you send them an email with it. And so you're right, as soon as you develop a trail online, either on social media, on your own website, or by email, you do at least have evidence of the moment at which something came into existence. I think it's good to be intentional. So I think before you upload anything to social media, I think it's good to familiarize yourself with terms and conditions. What do those terms and conditions say about intellectual property? What license is it that you are giving to Meta or whoever in relation to your work? And actually, the truth is, when you scrutinize it, it is a license that does mean that Meta can do what they want for the purposes of operating their platform. But actually, it's not an open invitation to the world to rip off your stuff. And so I do think once most artists have understood what it is they're signing up to, actually, they realize that it's not some Faustian pact where you're giving it all away. It's actually a reasonable license to the platform operator, and you still have all of your rights in relation to the rest of the world. But there are all kinds of reasons why, depending on what your work is, you may want to make sure you only put low-res images or put watermarked images. And that all of that is quite case specific and will depend on the particular nature of your own work.
Thanks for watching this video. If you want to watch the full 1-hour interview and get top tips from an expert, then click the link below and join the Art Ladder mentoring program now. By joining the Art Ladder, you will get access to our full library of webinars with curators, collectors, critics, gallerists, and more. Don't forget to subscribe to our YouTube channel for more videos like this, and check out the description below for more free resources for artists.